My lordship, I beg to mention one item that was read petition filed on 4th November, lordship. That may be listed for motion on Friday, fresh. Yes, lordship. Right. Obliged.
I beg to mention for listing one admission matter. Next week, anything. And 19 obviously. And one motion matter millet. I have filed so many bag millet. Motion matter millet. I beg to mention for listing motion matter millet. 19.
My lord, this is an admission matter, my lord. Next week, any date, my lord.
May I please, Lordship, the matter was earlier also mentioned, but not listed, my lord. The matter is related to a selection and appointment. The process will close on 14th, my lord. The matter may kindly list on. Yes, my lord. It has filed on 31st, my lord. 31st, my lord. Mentioned earlier, my today is fixed, but not listed, my lord. Tomorrow, my lord. Yes, my lord. For motion. My lord, on 14th, the process will over. Tomorrow, as today. Obliged.
May I please, Lordship? Lordship, with the consent of other parties, I beg to mention item number 18 to 22, Lordship. These are all tech matters, Lordship. Yes, Lordship. Respondent, Lordship. AFDC. Let it be after 4 weeks, Lordship, can it be? Yes, they have, yes, Lordship, they have. 22, Lordship. R3. Respondent. Yes. Obliged.
I beg to mention for listing of the case. Admission column 22 matters, my lord. Petitioner retired. There is disputed whether he regularized or not. Actually, regulation order is there. So affidavit short form not given. Last listed in 24th month. So two items, my lord.
My lordship, admission matter, my lordship, can it be on 20? Admission matter, my lordship, can it be on 21st of this month? 24th?
Lordship, I beg to mention an IFO listing on Friday, Your Lordship. IFO staying of disciplinary proceeding initiated against me. Lordship, we have earlier we have preferred an repetition, and there we have challenged the entire disciplinary proceeding. Now they have asked me to appear before them on Monday, Your Lordship, and bringing in new charges. And those charges are not mentioned in the earlier show cause notices, Your Lordship. Lordship, no, 14. On 17, I've been summoned, Your Lordship. And Lordship, and another item for withdrawal, Your Lordship, petition. Any date, Your Lordship. Published.
May I please, Your Lordship? Lordship, I beg to mention for listing or petition, Lordship, that was last listed on 15/5/2023, Lordship. There are 28. And another writ petition also, Your Lordship has granted the liberty to mention before this honorable court after the receiving the instruction from my client. Lordship, I have received the instruction accordingly, Lordship, that this matter may be listed in any day. Regarding the Lordship. No, Lordship.
May I please?
Highly obliged.
May I please connect? Lord, this matter admission matter, my lord, termination from service. 20. Obliged, my lord.
Please, Lordship. My lord, operative part of the order is at page 20, my lord. Operative part of the order, my lord. After.
Lordship, case 9, Lordship. An operative part is base 12. Case 9 is starting, Lordship. And 12 is the operative base, Lordship, then paragraph 7. I left it.
There was last order. The detailed order.
My lord, DPC has been held yesterday, my lord, and recommendations have been forwarded to the department, my lord. My lord, I don't know at present, but my lord, recommendation of the DPC has been forwarded to the department.
Lords.
Yes, my lord. But yesterday DPC has been held, my lord, and the case of the petitioner has been considered. The case of the petitioner has been considered.
Lordship considered, your lordship, ultimately whether my name has been. No, that your lordship only if your lordship that comes your lordship, because your lordship may kindly see, the ultimately your lordship, my challenge is to a particular advertisement, your lordship. On the ground that your lordship, I should have been promoted to that particular post, your lordship. But they have gone for direct recruitment to that.
And my lord, on last occasion, I submitted that post is different, my lord. And for the, because as part of. Yes, my lord.
Lordship.
Yes, my lord. No, my lord. Probably, my lord, since it has been forwarded. Yes, my lord, I understand, but specific instruction is. Yes, my lord. Yes, my lord.
Lordship.
Yes, my lord. Yes, my lord. Your lordship may take up on Friday, my lord. Monday, my lord. Yes, my lord.
Lordship.
Yes,
Assistant professor. Lords.
Yes, my lord. Sure, my lord.
Lords. Deeply
Okay.
obliged.
May I please, your lordship? My lord, here in this case, lordship, the petitioner impugned the notice dated 10/10/2025, lordship, page 79, lordship, by which lordship 202 posts of constable was lordship kept lordship vacant without filling that. Yes, lordship, the matter which by giving the numbers of the writ petition which lordship that post was kept vacant, lordship, that writ petitions fixed tomorrow, lordship. At court number 18, item number 18. Yes, lordship, that may be.
No, my lord, it will be prudent, my lord. Cause, my lord, he is challenging, he is aggrieved. Why 202 posts? We say that, my lord, because of the writ petition is pending, there is a direction.
Lordship, the petitioners are the Lordship qualified. That Lordship, who are not allowed to appear in the written test, Lordship. They are challenged. My challenge is that, Lordship, I have qualified all the process, Lordship. Because, Lordship, that there is a notice, Lordship, by which 202 posts was kept vacant. So, Lordship, we may have a chance to fill up because, and also the authority. My lord, relevancy is that, Lordship, the authorities kept vacant those 202 posts, Lordship, stating that the writ petition is pending and there are 202 posts, Lordship, 202 petitioners are there.
Petitioners and my lord, because of that, my lord, they have not annexed, but so far I remember, my lord, they are the direction, my lord, to keep those posts vacant since there are 202 writ petitioners. So, my lord, unless that and writ petition is, my lord, disposed of with a specific direction, either way, my lord, by this.
Qualified, Lordship. No, Lordship, that keep for vacancy of that 202 posts not filled up, we deprive, Lordship, because otherwise we qualified, Lordship. No, Lordship. Yes, Lordship. That in the final stage of selection, Lordship, in the Viva. Not selected, Lordship, but if that post will be, Lordship, filled up, then yes, Lordship. But due to keeping the vacancy of that 202 post, Lordship, we are not getting chance for selection. Oh, Lordship. We were not selected, but we are, Lordship, qualified in the physical test, Lordship, along with that, Lordship, I also challenges the merit list because they have not published any merit list, Lordship. Lordship, I have annexed the order of the court, Lordship, at page 111, Lordship, wherein there is no interim order, Lordship. Only observe that as such, this court is not inclined to pass any interim order at this stage, save and except observing that the action, if any, taken pursuant to the selection process in question shall be subject to further order that may be passed in writ petition. Yes, Lordship. These two writ petitions.
My lord,
Otherwise, your
either they
issue
become,
notice also,
my lord, they are against this order of this writ petition.
No.
Either they become a party, they implicate themselves there in the writ petition, or my lord, they have to go for an appeal.
Oh, my lord. There are no such specific direction for keeping vacant of 202 posts, Lordship. Lordship, we are not selected, but we qualified because the writ petitioners in those writ petitions, Lordship, they are not even qualified in the physical test, Lordship. And we qualified, Lordship. We qualified, Lordship, because they have not published any merit list, Lordship, and cutoff mark was also not. Yes, Lordship, but the merit. Yes, Lordship. Yes, Lordship, because that merit list they have not published, Lordship. So cutoff mark, Lordship, we also not, Lordship. Yes, yes, no, no. Lordship, I am not praying for keeping the vacant those posts, Lordship. I am just praying, Lordship, that due to that notice which was published just prior to 1 day from the date of Lordship publication of result, Lordship, they have notified that 202 posts would be kept vacant due to that those two writ petitions, pendency of those writ petitions. I am aggrieved by that order. Along with that, another additional prior, Lordship, that they have not published any merit list, Lordship. Yes, Lordship. So at this stage, your Lordship may issue notice also, Lordship. My lord. My lord. Yes, my lord. My lord, my prayer is that, lordship, I have appeared in the lordship rigorous. My lord, your lordship may kindly see.
My lord, I just want to bring on, I have just checked the orders, my lord. There is an order, subsequent order on 25/9/25. 25/9/25. This referred writ petitions, my lord. There is a specific direction by this honorable court to keep, my lord, the post vacant. 25/9/25. I can, my lord.
Along with cut-off marks, lordship. But this is the lordship, law of recruitment process, lordship, because but that page 36, lordship, select list will be prepared for the exact number of vacancies to be filled up. So 36, lordship. The advertisement, lordship.
Not select.
Yes, lordship. Yes. Yes, lordship. My lord, even they have not prepared any select list, lordship. Because, lordship,
How can, my lord, without selecting a select list?
my lord, only on the online process, lordship, we get our result, lordship.
That means what, my lord? We have a select list.
So subsequently, I have discovered, lordship, due to keeping, because otherwise, lordship, we would be eligible and we will get selected, lordship. Because of keeping the vacancy of those 202 posts, lordship, we 20 petitioners, 21 petitioners, lordship, we are not, lordship, accommodated.
There is no way, my lord.
My lord, there are some two prayers, lordship. One prayer is that, lordship, that due to keeping the vacancy of those 202 posts, and another additional prayer, lordship, they have not published the lordship list, wherein, lordship, the detailed marks along with the cut-off marks would be required to be published, lordship. For all the candidates, lordship, those. Lordship, at least. Number.
Yes, I don't know.
My lord, may I?
তোমালোকে সাধাকে order কিয় লগাই যাওক? পিছৰ order কিয় লগোৱা নাই? Just stay কৰি থৈছে। বিচাৰি পোৱা নাই তোমালোকে কি এইটো লগাব পাৰে ইয়াৰ পিছত 4টা order ওলাই গৈছে। এইটো মেইন ৰিট পিটিশ্যন তোমাৰ এইটো। এতিয়া মই দিয়া তোমাক এইটো হ'ল কি এইটো 4টা order ওলাইছে।
At a level of 657. 6. 606.
Lord, Get just information, Lordship. Similar writ petition, Lordship, was listed, Lordship. That was pending, Lordship. Similar challenge was made, Lordship, to some writ petitions.
606.
6065.
My lord, 25/9/25. On not only this, there is series of writ petitions, my lord.
That is what we do.
My pleasure, Lordship. Well, the petitioner before your Lordship are working as a, my lord, basically driver and technician of a Mrityunjay, my lord, ambulance. And they have been forced to work for 12 hours. But law says, my lord, 8 hours is the time, my lord, and overdues. My lord. And only one thing, my lord, pendency of the case may not be a bar, my lord. Yes, yes. The authority has passed order basically, my lord, but that has not been implemented. That order, Lordship, will see a kind of minor space 94 onwards, man. And they have taken decision also, page 94, my lord. First one, overtime payment. The management will ensure the payment of the overtime wages of the eligible employees in accordance with the provisions of minimum wages. My lord, otherwise it's a implementation. But I have approached. I have approached. This is the. My lord, I approached to the Labor Commission, page 79B seen, my lord. 9. Oh, 79, I said. 79, they said, my lord, Roman 3, my lord, relating to the duty hour shifting. My lord. Yes, yes. 94 is the, my lord, minutes of the meeting. My lord. That minutes, if it is implemented, my lord, the. My lord. My lord. Nothing happened, my lord. No order, nothing, my lord.
Lordship. Lordship. We'll get instruction, Lordship.
Over.
NIH, I'm referring to my lordship. Respondent. Three. Respondent number 3, your lordship. Yes, yes, I am for 2. Lordship.
Only one more thing, my lord, lordship, kindly turn up to page 87, my lord. I have approached to the labor commissioner also, my lord. What is the fate of that? Last,
Lordship, the name of GA Assam may kindly be shown, Lordship. This is not reflected. No, hold on, we still have one another. Clear.
কিতাপবিলাক নিনিবা। চব থাক, তুমি পাছত।
Matter is regarding non-payment of salary, lordship. Petitioner number 1 to 7 were working as in various posts, lordship, in Artfed. 8-1 and 8-2 are the legal heirs of one Onchumuni Besbora, lordship. She was working in Artfed. She has already retired and expired also. Yes, lordship. But lordship,
My lord, I have gone through the order. It's based on an, my lord, affidavit filed by the Artfed. So, my lord, I am not appearing for Artfed
Yes,
here.
lordship.
I will just appear for, my lord, Handloom and Textile. Notices to go, my lord.
notices to go.
One and 2, my lord. Mr. Chalia is there, my lord, for finance. Same now. One order.
Yes, lordship.
My lord, steps has to be taken for this
Yes,
Artfed, my lord.
present.
My lord. So, yes, my lord.
Eight-
Deeply obliged.
8 is also similar, lordship. Matter pertains to leave salary and gratuity only.
6 and 8.
6 and 8, yes, lordship. Obliged, lordship.
My lord, is a dismissal from service. My lord. Appeal is also rejected. My lord. My lord, police department, my lord, having that. Yes, my lord.
Yes, Lordship.
All. All.
Lordship.
Deeply obliged.
Obliged, your lord.
Please, your lordship. Regarding non-payment of the salary, your lordship. Lordship, since July 2019.
Lordship, as per the telephonic instructions which I have received, Lordship, the petitioners were not appointed, Lordship. No appointment letter is there. They were just being called on as and when required basis. Although,
Lordship, sir. Petitioner. The workshop sweeper in water resource deputy. July 2019.
one to four, Lordship. AG.
appears.
Yes,
Deeply obliged.
May I please, your lordship? My lord, what has happened, my lord? Pay had been fixed, my lord, at page 20, annexure 1. Here, my lord, what they have done, as similarly placed incumbents, my lord, all were drivers under the, my lord, Silchar Medical College and Hospitals. If my lord can peruse the scale of pay, that is, my lord, for the first two persons, my lord, it is 2890, starting, ending with 4480. And for us, my lord, it is 2650, ending with 3310, my lord. So therefore, my lord, this discrepancies continued to the later on also, my lord. And in page 22, annexure 2 also, the fixation has become erroneous. So, my lord, then during this course, my lord, I was though working as a, my lord, driver. And now my condition is very pathetic, my lord, is in a bedridden condition due to diabetic and other ailments. So, my lord, I made a representation also, my lord, at page 26, annexure 4, that that erroneous fixation should be rectified, my lord. But that has not been acted upon. And as a result, my lord, my pensionary benefit is also in a reduced rate, my lord. So, my lord, may I pray, my lord, a notice is required to be go, my lord, a response is required, my lord. Or if my respected friend take instruction that why this happens, can we sort it out?
Lordship, I'll take instruction, but he was retired in 2013,
That is correct.
1-3.
There
And
is a delay.
representation submitted 2022.
22. My lord, there is a delay, my lord. We have narrated a
And
paragraph.
2013 to 2025. Definitely he is getting the earlier pension and he's taking definitely.
Yes, yes. At this moment, my lord, pension I am receiving, my lord, but it is in a reduced rate.
Now,
That is in a. My lord.
yes.
My lord, if the fixation is rectified notionally, my lord, then I will maybe entitled to my some area also, my lord.
I pay for 6 months. Yeah.
No, I'm one. I'm 1, 4 and 5. Copy দিব দেই, copy দেন। Copy দিব।
Oh, yes. My. Mal. Obligation, highly obliged.
May I please, Lordship. Lordship, this matter is regarding pension and other pensionary benefits. Lordship, the petitioner was retired from his service on superannuation on 31st of December 2024. He was working from 1986, Lordship. Lordship may come to page number 45. Earlier, writ petition was filed by the petitioner and this honorable court disposed of, and direction was given for regularization of the services. Page number 40. Page number 45, Lordship, Annexure 11. 45, Lordship. Yes, Lordship. According to the petitioners, they are entitled to receive their salary from 2000. It is the further plea of the petitioners that they are also entitled to regularization of their services. As stated in the writ petition, they are serving as work search assistant since 1993. The petitioner was also working as work search assistant, Lordship. While entertaining the writ petition by order dated 18/7/2005, an interim direction was issued to scrutinize the claim of the petitioner for their salary stated to be payable from July 2000. It was further provided that upon such scrutiny, if it is found that they are entitled to receive salary, they should be paid the same. Even after expiry of about 8 years, the respondents have chosen not to file any counter affidavit. Interim order.
Page 34, Lordship.
Page 34, Lordship.
There is a direction to pay the salary, Lordship.
This is the order, Lordship, page 45. They are also entitled to regularization of the. And these honorable could dispose of this writ petition, Lordship. And one interim order was, dear Lordship. Yes, yes, Lordship.
Petitioner is directed to be entitled for regularization. It's the wrong statement. On this ground, we are discussing your.
I apologize, Lordship.
How will you find the petition by reading all these statements? Very good. They give you time to rectify.
Yes, Lordship. Marvelous, Lordship.
Right.
Yes, Lordship.
There is a categorical statement that wanted page. Earlier proceeding and that it's very. Reading appears to be not a correct statement.
Yes, Lordship. Marvelous, Lordship.
1 to 5.
Irrigation.
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 No, please, your lordship. Matter regarding for releasing pending salaries. Lordship, the respondent authority kept holding my salary from 19/12/2024 to 2/7/2024. The respondent authority bypassing order in page number 12 and 13 kept away me from my work. Illegally. And hold my salary from this period. Subsequently, this honorable court has set aside the said order of the respondent authority. The respondent authority had passed the order without authority and without jurisdiction. There was no fault from my part. As such, the respondent authority cannot deny to pay my salary.
PC Musahari, respondent 4 and 5 for BTC lordship.
Two lordship. One.
And respond number 3, your lordship.
Lordship, I'll appear for one.
It does.
BC Musahari lordship.
Yes.
Your lordship, this is second round litigation lordship filed by the petitioner lordship. Hearing petitioner number 1 presently major lordship, but at the time of death of her husband lordship, she was minor. So lordship, the previous occasion honorable court has disposed of this petition with a certain direction lordship.
Honorable Court Order, Lordship, dated 25/6/2025, Annexure J, Your Lordship. Kindly be produced. No, okay. Page number 44. This honorable court has passed the order, Lordship, dated 5/6/2025, Lordship, wherein 11 person is page number 49, Lordship. Direction, Your Lordship. May please to read it. Under such circumstances and from the document enclosed to the writ petition, it is seen that the petitioner number 4, who is the son, has already possessed the age of 21 years and therefore he not be entitled to any family pension benefit. It is projected age before this note is correct. However, he is entitled to get other retirement benefit as permitted under law. The petitioner number 2 and 3, being the minor daughter, are certainly entitled to get family pension and other retirement benefit. The authority will forthwith take up the matter and call upon the petitioner number 2, 3, and 4 to furnish their necessary document. Thereafter, process the matter by apportioning the family pension and other retirement benefit among the present petitioner number 2, 3, and 4, as well as the respondent number 9. And her children, the next of kin certificate dated 7/7/2022 shall be submitted in original or a duly attested copy, therefore, before the respondent authority by respondent number 9. Let this exercise be completed within a period of 60 days. Next, the petitioner number 2, 3, 4 are also at liberty to furnish a certified copy of this order before the authorities concerned, more particularly by the Director General of Police, and thereupon respondent will take up the matter in terms of law and apportion the pension as expeditiously as possible. After obtaining such order passed by this honorable court, she has approached before the authority. Therefore, authority Director General of Police may communicate it to the Commissioner of Police asked to make an inquiry and thereafter passed an order. Accordingly, the Commissioner of Police has passed the order, speaking order dated 4/10/2025, that is Annexure L, Your Lordship, page number 54. But very interestingly, Lordship, the Commissioner of Police has not gone through the merit of the case and not properly scrutiny, but finding he has stated that, Lordship, that is the order, Lordship. May I please to read the impugned order, page number 54, Annexure L, Your Lordship. This order, Lordship, that is the yes, Lord. Then of the second one, the previous writ petition, honorable court has made the proper observation and there is a direction of this court, Lordship. But very interestingly, Lordship, the order passed by the speaking order passed by the Commissioner of Police, Lordship. May I please to read. Subject action taken report in compliance to the direction of the Honorable High Court in its order dated 25/6/2025, passed in writ petition number so under so, Madam, with reference to the subject cited above, yes. No, at the relevant point of time in my writ petition para number 3, Lordship, I have categorically mentioned, kindly be perused my writ petition para number 3, Lordship. Page number 9, Lordship. Kindly be perused. On basis of the birth certificate, Lordship, this list I have prepared, Lordship. That is the date of birth of the petitioner, that is on 10/9/2006. He was date of birth and
Yes, Lordship. One, 2, 5, 6, 7, 8, and 11.
Nine and 10, Lordship.
Yes.
Two, three, and nine.
Your lordship, interim order may can be granted. Your lordship, the previous occasion lordship, the interim order also granted to me. Your lordship, not to disburse the 50% of salary lordship, which is apportioning, they are entitled to get such benefit lordship, as because your honorable court, there is a direction lordship, previous occasion lordship. Yes, your lordship, that is the page number 25. Page number 25. This honorable court has also direct. No, not 25, page number 49 lordship. Wherein directed to share proportional share between us lordship. 50% definitely entitled to get the minor children of the arising out of the second marriage. Your lordship, there is a order, there is a several judgment of the Honorable Supreme Court lordship that the children out of the second marriage entitled to get pensionary benefit at least 50% lordship. There is a direction lordship. Otherwise, lordship, the first wife has now it has came to my knowledge that the first wife has already availed such pensionary benefit. Even also she also making fraud lordship in the next of kin certificate, kindly be perished lordship. I have annexed here lordship. Next of kin certificate. Next of kin certificate. Your lordship. Page number 38 lordship. Kindly be perished. 38, that is the next of kin certificate the first wife has obtained by making it fraud, as because your lordship, that is the age of the girl has shown. That is the Deepa Monikus. Deepa Monikus, her age was shown as 18 years. Page number 39. Very interestingly, your lordship. Then obtaining such document, she has submitted and she has collected the pensionary benefit is the way, your lordship. And the entire snake has came upon only for us lordship at the time of hearing of the previous writ petition lordship. Then lordship, even the Zuti son, another data Sikha son as 15 years, but at a relevant point of time, her age was 15 years. So the first wife have obtained and she is receiving pensionary benefit by making it fraud. Otherwise, lordship, you will get benefit lordship. Your Lordship kindly permitted me to impede the party respondent number ABCD Lordship. Now, KG, I did not impede the party. Your Lord. Leave the-
Well, in this case, I have an challenge, my lord, the inquiry report, my lord. Similar repetition has been pending before this honorable court, my lord. Two death of birth were there, my lord. Deaths of birth, my lord. That is why, my lord, we challenge.
Madam. Respond number 135. Sorry, my lord.
My lord, this matter is, another matter is pending 2111, my lord. So matter may come along with this.
My lord,
The
20.
yes, yes. Then. I will ask.
It please, your Lordship. Lordship, this is the second round of litigation, Lordship. In the first proceeding, my lord, we have filed for not considering the case of the petitioner for our application for compassionate appointment by the SLC. And thereafter, my lord, it has the SLC, my lord, submitted a, my lord, order, page 42, my lord, where in serial number 41, my lord, serial number 41 is the petitioner before your Lordship. My lord, applicant does not possess required educational qualification for grade 3 post. Applicant's application for pending for recommendation for more than 2 years. Therefore, the applicant spent its force. So that proceeding was, my lord, earlier proceeding was closed because, my lord, it has already been considered, and the honorable court has given us the liberty to challenge this, my lord, this impugn order, my lord. And by way of filing this application, my lord, I have challenged this order because, my lord, on the very date, my lord, I was very much eligible for grade 4 also. And, my lord, even without hearing me, no communication of nothing, my lord, was issued to me in my favor. Yes, yes.
My lord, the petitioner's father died in 1994.
Yes, yes.
My lord, matter relates to, my lord, the recovered risks and hardship allowances, my lord. My lord, as per the OM dated, my lord, 16/8/2024, my lord, that is annexure 8, my lord, page 56. While, my lord, the petitioners were serving, my lord, the 27 Battalion, my lord, Hauli, my lord, Borpeta, my lord, for the period, my lord, March 2019 to May 2022, my lord. My lord, one order has been passed by this honorable court, my lord. That is, I have annexed, my lord, page annexure 11, my lord, page 93, relevant page, my lord, 98. Same notification, my lord.
Mal. That is just notice one.
Yes, my lord, the interim was granted, my lord. Without leave, my lord, no recovery. My lord, that is, page 98, my lord, order dated 4/4/2025, my lord. The
54, page 54.
page 54, my lord, impure notification, my lord. Annexure 8, my lord. 56 origin, my lord. Rank of my lord, we are petitioner, my lord, all are my lord, the gazetted post, my lord, that is deputy commandant, my lord, and commandant, my lord. Yes, my lord, but my lord, our petitioner grievances said there was no misrepresentation or fraud, my lord, and they have any no acknowledgement. Yes, my lord, the paragraph 18, my lord, it was cleared, my lord. But my lord, the right to equity is come, my lord, in this. Yes, my lord, so my lord. Sir. Yes, my lord, pending.
All respond.
One 1870, 23. Master oblige.
Supplementary list on motion item 37.
May I please, your lordship.
Yes, Lordship, in this case, Lordship, after the instruction received, Lordship. So for what happened, Lordship, the proposal was submitted before the government by the director, Lordship. And after that, Lordship, after verification of the proposal, Lordship, the director, the government issued some queries and asked the director that to submit the proposal as per the checklist required in the finance department, Lordship. And thereafter, Lordship, on 6 November 2025, Lordship,
we received the fresh SEC list, Lordship, that was submitted by the director, Lordship, and now after verification, Lordship, we will move to the finance, Lordship. That is the status at this stage, Lordship. Note at this stage, Lordship, notice may go, Lordship. During this period, Lordship, we will did all these things, Lordship.
My lord, the petitioner will be returned in the month of February, my lord.
Yeah, but date may be fixed, Lordship. After 2 weeks, Lordship, notice may go. After 2 weeks, date may be fixed. Lordship.
My lord, may observe the process may be completed within 1 month.
No, that will be the final disposal, Lordship. During this period, Lordship, we will complete, Lordship. Because, Lordship. Lordship.
38.
The petitioner, while working in the 175 veteran CRPF lordship, they were provided risks and hardship allowances lordship in view of the office memorandum dated 31st. Yes, lordship.
Lordship, I have not got any instruction, but though it is as it is similar, so Lordship kindly fix it day after tomorrow so that Lordship can dispose it on the motion stage, Lordship. Lordship, in the meantime, I will take instruction, Lordship, or Monday, Lordship.
Yes, Lord. Annexure 4 lordship is 125. Yes, point number 4 lordship. Yes, lordship. With effect from February 2019 to January 2023.
Done.
Lordship, till date, some stay order may be passed, lordship.
So this is on 20
Yeah,
May,
so for my
May
instruction,
order,
lordship.
Lordship.
So for my instruction, lordship, within 15 lordship, November, they are passing some order, lordship. Therefore, lordship, only for.
Then I said, day after
Till-
tomorrow, I will take instructions. Lordship. A copy may be kindly, maybe sir, during the course of, I think.
Daily list for order item 17.
Meet is your lordship. Lordship, Mr. R. Sharma, Randeep Sharma, he was about to appear in this matter. He fell ill, lordship, he had to leave the court. Can the matter be adjourned for today, lordship?
Jay Gayan. J. Gayon. Yes, ma'am.
I'm obliged to.
Item 25. Item number 23.
Twenty-three or 25?
23.
Item 23, Lordship. Lordship, also for the timing, Lordship. For timing, Lordship.
24.
Here we have appeal file on 24/9. Order not completable, we have preferred and writ appeal. That appeal was, Lordship, appeal is not numbered. We file on 24/9. Some steps are required to be taken. We have taken the steps before the vacations. We have filed. Lord, I have taken the steps. Lord, kindly allow me some time. Lord. Order is 25/6/24. 24. Lordship. 7 of 22. Lord. How long?
Sorry, my lord. Item 23, date may be fixed for hearing, my lord. Yes, my lord. Sorry, my lord, sorry, my lord. Sir, in any date, my lord, needs to take, my lord. For hearing, my lord. It is, it is orders column, my lord, that's why, my lord. Today, my lord, in this case, my lord, Jayadin will appear, my lord. Last time, it was listed for hearing, my lord. But lordship's ordered that the matter may be fixed for orders and then refixed as a hearing, my lord. December, my lord, any date, my lord, in the first week. December. Sorry, my lord. Sorry, my lord. Exclamation. Compulsory retirement, my lord. Yes. Pleadings are complete, my lord. Last occasion, my lord, matter was listed as a hearing column. In the December, my lord, petitioner not getting any salary also. December month, first week or second week, my lord. Obliged. Obliged.
Item 25 and 26.
My lord, here, my lord, they have disqualified me
I am seeking for a post under persons with disability quota, my lord. And they are saying that my disability is 23%, whereas I am saying that it is more than 50%. I am a person with benchmark disability. Now, lordship may kindly take up the affidavit filed by the respondent number 6. It starts from page 106. Respondent number 6 is the principal cum chief superintendent, Guwahati Medical College and Hospital, Guwahati, Assam. Kindly come to page 109. What they have to say now? Page 109. Now, my lord, second paragraph, my lord. My lord, I'll read from the first paragraph. It is relevant herein to mention that as per comments of expert members of the medical board, his hearing disability was found to be 23% in both years on both examinations. It is, however, contended by the writ petitioner that his disability percentage is higher than the remarks given by the medical board, and he has submitted reports of a hearing test which is not in the knowledge of the medical board. Oh, page 109, my lord. Yes, this is the affidavit of the respondent number 6.
109.
Serially 109 likha ase to.
It is different. 124.
Oh, it is different. Code copy.
Sorry, what it's 124.
124, my lord, code copy.
No, dear. Itu copy thing. Item to ulta pulta piece.
My lord, my lord. My lord, I am reading page 120. 127, my lord. 127. It is relevant herein to mention that as per comments of expert members of the medical board, his hearing disability was found to be 23% in both years on both examinations. It is, however, contended by the writ petitioner that his disability percentage is higher than the remarks given by the medical board, and he has submitted reports of a hearing test which is not in the knowledge of the medical board. It is also relevant to mention herein that as per report submitted by the head of the Department of ENT, Guwahati Medical College and Hospital, Guwahati, there are some variations as regards to the writ petitioner in the hearing test reports done by the petitioner. In view of the above, it is likely that the writ petitioner has progressive hearing loss disease. As such, the petitioner herein requires a re-examination by expert members for knowing the exact hearing disability as on date. Now, my lord, they are suggesting, respondent number 6 is suggesting for a retest. Now, my lord, I have all the test reports. I am a person with benchmark disability. I am certified, my lord. I have my IDs. Kindly come to page 45, annexure 10 of writ petition 2321.
Photocopy 26. Photocopy.
My lord, this is the first I am showing from there. It is there also.
26.
Item number 26 I am referring, my lord. Yes, both matters is available. That is, lordship is taking up writ petition 2869. Then lordship my lord, kindly come to page 45, my lord. Annexure 10. My lord, this is my ID card, my lord. Unique disability ID issued by the government of India, my lord. Here specifically mentioned, my lord, next to year of birth, percentage is 86%. 86% disability, which was issued on 6/8/2021. Next, my lord, kindly come to annexure 11, page 44. Here also, my lord, at serial number 4 in the table, hearing impairment, specifically mentioned, my lord, left and right ear, 86.25 and 93.75 respectively, my lord. And my recent test reports, my lord, thereafter, page 48, annexure 14. Annexure 14, this is the brainstem test. So here also it is given page 48, right ear is 70 and left ear is 70, my lord. It is above 50. I use machine, my lord. I cannot hear without machine. It's above 50. I am a person with benchmark disability. In their test, they have given it 23%. Now they are saying that a retest is required. Now when I am a certified person with benchmark disability, whether so many tests are required at this moment, one, or this honorable court would like for a retest as per the submission of the respondent number 3. That I leave to your lordship. But lordship, if lordship is directing for a retest, I would pray that this petition be kept pending and in a time-bound manner they may do the test, keeping in view the reports, earlier reports. That will be my prayer, my lord, before your lordship.
Lordship, that can be done because Lordship, they have stated that there are chances of variation in this case, Lordship. So Lordship, since they have also suggested, Lordship, a test can be done at GMC, Lordship.
GMCH, my lord, the
Principals.
respondent number 6. But otherwise, my lord, I am a certified individual.
Excellent.
43. Well, lord.
Yes, Lordship.
This disability ID indicates 86%.
Yes, Lordship. Yes, Lordship. 21. The joint director, Lordship. Lordship, some test needs to be conducted for issuing this, Lordship. There will have to be some test, Lordship. Yes, Lordship. Yes, Lordship. As permanent.
And then saying that no, he's
Lordship, because Lordship, here, Lordship, the test was conducted in the GMCH by an expert body, Lordship. So, yes, Lordship.
correctness, everything, then they have to the matching that the ID is incorrect.
Lordship,
Why those steps are taken?
Lordship, there is series, Lordship, which is pending in the same issue, Lordship, where there are identity card issues. Yes.
Health department, the health department.
Yes, Lordship.
The person is in the the health department.
Yes, Lordship.
The state health department is not authenticating your own ID.
No, Lordship, because PWD candidates, Lordship, there are few variations in the case of hearing or vision, Lordship.
Then this variation, the person who conducted the test.
Yes, Lordship, in 2001. Yes, Lordship.
But going by the ID, the appealer, does the disability is different.
Yes, Lordship.
And if a wrong ID has been issued, then the authority has to be taken to task.
Lordship, I'll get Lordship specific instruction to this also.
What do you want to do now?
Lordship, let it come on Friday, Lordship. I'll get the instruction, Lordship.
That instruction from Boundary.
No, Lordship.
All the.
This is Lordship
I think that we don't have. You can query, you don't have the answer. And you want everything on Friday.
Lordship, it is from Kamrup Metropolitan, so Lordship, I'll get the.
Just call this asking for the.
Lordship, let me have the instruction on Friday, Lordship. I'll get this. It is from the Joint Director Kamrup Metro, so I can get it, Lordship.
And I would like to apprise this honorable court that they are going to make appointments to this post.
Lordship, this is.
Already processes, they have started the process as per instruction. And so Lordship, from the day one, they were pressing against the
I guess our prayer for
Lordship,
interim.
Appointment, Lordship, we are not issuing, Lordship. It is the concerned department, Lordship. Query, Lordship. Yes, Lord.
These legal, these confusions are created by the department.
Yes, Lordship. Anything coming for pleasure as a big.
Also back with the corporate.
For respondent number, TN. SL. This is informed. Yes, please.
One and two, so personal department.
As you say, এইখন যদি তোমাকে ডিসক্লোজ করা নাই, এটা কেনেকে হচ্ছে পার্মানেন্ট ডিটি নাই।
$50. No? 50 or 40?
It will be
40. 40, sorry. I stand corrected, my lord, 40. My lord, may I pray for to consider our interim today, my lord? Till next day, they may not make an appointment, my lord. One post may be kept. My lord. Yes, my lord. I'm grateful, my lord. I'm grateful.
I think 27.
Lordship, in this case, notice was issued upon respondent number 123 on 24/1/25, Lordship. And we have taken steps, and Lordship may kindly peruse the last page of that contempt case, Lordship. Therein, Lordship, the service report is there, but it's not being reflected in the office note, Lordship. I have of that contempt case, Lordship. I have marked it with a blue flag mark, Lordship. The backside, Lordship. One Ratul Das has served it, Lordship. Yes, Lordship. Subsequently, for respondent number 4 was implemented, and I had taken steps on them on 6/6/25 to raise that post, Lordship. I have one prayer, Lordship, that I may be allowed to take steps upon respondent number 4 through usual process, Lordship. Additionally to this one, Lordship. 1, 2, and 3, that service report is not reflected earlier also in this case, in respect of respondent of 1, 2, and 3, Lordship. So that service is complete in respect of 1, 2, and 3 in respect of.
Although this note reflects not received the account served. Process service report. Because service is nothing but 1, 2, and 3.
Yes, Lordship, but that was also not complete, Lordship, in respect of 1, 2, and 3, Lordship. Yes, in the office note, it's not there. Yes, Lordship, they have received it, Lordship, but none has appeared in respect of 1, 2, and 3. In respect of 4, Lordship, it has not been served probably. Notes. In respect of Lordship. Lordship, as well as by usual process, Lordship, because the report in respect of respondent number 1, 2, and 3 came by usual process only, Lordship, by rest. I'll take, Lordship may kindly allow by usual process also. Oblige.
28.
Respondent number 1 filed affidavit in opposition, my lord. I think 2 weeks time may be granted to file rejoinder. my lord.
Lordship, I am on behalf of one Lordship.
Oblige.
29.
My lord, he is appearing.
Lordship, I am for account.
Yes, number 4.
4, my lord.
Three has received, my lord, the copy long back. 5 mile and landed.
No, my
4. Then matter will place before the Luajama, my lord.
I was also.
Item 30.
So this for non-compliance of the order dated 18/11/2024.
Lordship, in this matter, I am seeking some time, Lordship, although we have received instructions, but it is not completely instruction, that's why.
Regarding
Yes, sir.
the non-release of the subsistence allowance
Subsistence allowance, yes, Lordship.
earlier.
Lordship. Lord. Lordship, 2, RM Das.
The date may be given, but it's possible.
Lordship.
Much service.
31.
Well, 1st December. It may be 2nd December, 1st December, I do not. Oh.
May the Lordship, my lord, steps were taken upon the respondent number, all the respondents in their respective official address And as per last office note 411, my lord, neither ID card nor unserved notice has been returned. Steam to be served, I don't know, my lord. I should do that. Containers are, they're evading their office orders. Um,
32.
This case, my lord, the respondent filed Wakalatnama, one of the respondent of the Security Department.
Lordship, I am appearing for 4 minor. 4 minor.
In the meantime, my lord, postal checking report may be verified by the registry, my lord. Right.
33 and 34.
My lord, I have already complied.
My lord, here, Mr. M. Sharma is appearing his on Lex.
Already complied, my lord. Yes, my lord. I have,
My lord, I need instructions from the M. Sharma because he's appearing this matter. Obliged.
Supplement release for orders item 39.
This IA is for correction of the order, lordship. Order is at page number 11 of the IA, lordship. Third line of the operative paragraph, last paragraph, lordship. This code directs that the post of Anganwadi helper in 137 number Dolgova Poalpara, page number 11, lordship. Operative paragraph, last paragraph, lordship. This is the Anganwadi helpers should have been Anganwadi worker, lordship, because petitioner is already working as a helper, lordship. That's all, lordship.
No, lordship.
Acknowledged, Lordship. Yes.
Secretary for admission, item 40.
Dispose of project. Your Lordship, the matter as
This
such
is
can
regarding
be
compassionate appointment, madam. This is a cover case, madam. As per Abdul Qadir Bakshi judgment, madam.
Lordship, now, in terms of the judgment rendered by the quoted bench of this court in WPC 342, this writ petition was filed on 13/2/2025, so it is covered as such. So the department has come out, the personal department has come out with the OM, which is a flag A, wherein, as per that particular OM, they were supposed to, petitioners are supposed to file their respective applications. And in flag B is the format in which it is to be made, the application has to be made for compassionate consideration of the compassionate appointment. And this time as such was extended very recently till December 2025. So they may approach and the matter can be disposed of in terms of this OM.
Where is Malabhi? These are just filed up before now. Before I have filed. Uh, 3/4/25.
Para 9 and 10. Earlier it was 15/9/2025. Till December 2025. So this is the first page is the letter written to the senior government advocate seeking further 2 months time in addition to the decision. Your Lordship is the not next in this particular set of instructions, but it is till 31st December. I am submitting at the bar, Your Lordship, 2025. There is no extension OM as of now. Lordship. Lordship, the leave was taken from the honorable court. I have to produce that particular order, Your Lordship. I'll supply it after some time, Your Lordship. Your Lordship. Or tomorrow, Your Lordship, if it is not possible tomorrow, today, Friday, Your Lordship.
Applies.
Lordship, last occasion, the respondent number 5 was asked to file affidavit, my lord. That is not filed yet. The block development officer. Last occasion, Gogoi was, my lord, he was.
PHA करना है block video ना hold.
My lord, PNRD department.
And Kondita, your lordship. 1 and 4, PHA department.
My lord, a date may be fixed.
That I am appearing for respondent number 7. K. Zaman. Respondent number 7, madam.
November.
Obliged to.
42.
See, the petitioner is aggrieved by the
Well-
non-payment of regular pension and gratuity.
In this matter, my lord, we have received the pension papers from the parent department on 3rd of this month. So it's under process. It will take another 2 weeks, my lord, to issue the PPO, my lord, if everything is found to be in order.
That may be fixed, lordship.
And Adhar for respondent number 1 and 2 PWD.
Third of this month.
November. Lot. Obliged.
I think 43.
Interim orders. May it please your lordship. So the basic query of this honorable court, otherwise we have completed all our submissions, that there is a interim order, and the interim order, it appears to be as if the final adjudication has been done. So that is the query raised by this honorable court, and I'd like to address on that point. And if lordship is allowed me to place that order. We have against that interim order, lordship, yesterday lordship was pleased to say that we could have gone to the division bench to get it. review or whatever, but we filed a vacating petition of that order. Lordship will kindly take IA 170/2020 in the same batch of them. Order the 170/2025. This IA we filed before the same bench, Lordship. I mean the learned single judge. No, it was not notified. When this was taken up, both the parties agreed that instead of taking up this matter for vacating, the final hearing can take place. Right?
Yes, because it was an inter-party order, my lord.
So that,
25.
Lordship, interim order, we filed a vacating petition. Let us go this to the order passed on 29/2010. I will come step by step, page 22 of the IA. 22. So it is a part of that order. 29/2024 heard so and so, first paragraph, second paragraph. By way of this interlocutory application that is filed by the other side in WPC 213125/2024, the applicant is seeking inter alia direction for restraining the state authorities from giving effect to the impugned so-called notice dated 2/9/2024 issued by the Director of Welfare and of SC and SCPC. So the prayer was to stay the operation of that because initially notice was issued, no stay was granted. Here the application for in the IA, the prayer was for restraining the state, that means keeping in abeyance. And in that case, Lordship, may I place to few paragraphs? Paragraph 12, in the meantime, the applicant sought for reinstatement in service by revoking the suspension order so-and-so. Thereafter, the Deputy Commissioner Jorhat by order dated so-and-so revoked the cancellation order, whereby OBC certificate of applicants stood revived. During the pendency, however, during the currency of the judgment dated 1/6/2000 passed with division bench in so-and-so, subsequent enquiry was held by CID on 31/7/2023. From here, the second stage starts, the subsequent enquiry. By that time, already the learned single judge as well as the division bench passed an order. Yes, Lordship, I'm coming. Serially, I'm coming. Written some finding, whether that finding is final or interim. That's the only query. If to that query, the law is well settled. Because Lordship will kindly just page 34 of that order of the same page. This is the finding, final. Because while passing this order, the learned single judge did not gone through the affidavits, would not gone through the contentions of us, did not go through various findings in the subsequent enquiry, only on the basis of two orders of the division bench as well as the single judge, the learned single judge was pleased to give his opinion at paragraph 40. The so-called notice dated 2/9/2024 is illegal. This is where the problem started because the prayer was for to keep this notice in abeyance. And as such, this court stays the operation of the so-called notice bearing so-and-so till the final disposal of the WPC. So our side was not heard. When my learned friend was about to make detailed submission, then the Honorable Court very clearly said, I'm not doubting anything now, that you make all this submission at the final hearing. But this word is clearly creating problem, illegal. That is a opinion. But there should have been another line that these observations are temporary. That observation is not there. But whether that will still make the final determination at the interim stage as the final determination of the case. Determination at the interim is and determination at the closing of the final hearing are two different issues. So to that effect, Lordship, a judgment of the Honorable Supreme Court in a case of State of Assam versus Barak Upatyaka DU Karmasari Sanstha
2009, 5 SCC, page 694. State of Assam versus Barak Upataka DU Kormosari Sanstha. The relevant paragraph will be, Lordship, paragraph 21 and 22. Paragraph 21, may I read it, Lordship? A precedent is a judicial decision containing a principle which forms an authoritative element termed as ratio decidendi. An interim order which does not finally and conclusively decide the issue cannot be a precedent. Any reasons assigned in support of such non-final interim order containing prima facie findings are only tentative. Any interim directions issued on the basis of such prima facie findings are temporary arrangements to preserve the status quo till the matter is finally decided, to ensure that the matter does not become either infructuous or fait accompli before the final hearing. So they have made the right prayer, but one wrong word was inserted. But that will not change the color of the interim order. Interim order is interim order. It is not the final outcome of the final determination or final hearing. So the Honorable Court very clearly, any interim direction issued on the basis of such prima facie findings are temporary arrangement to preserve the status quo till the order, matter is finally decided, to ensure that the matter does not become either infructuous or fait accompli before the final hearing. The observation, paragraph 22, the observations and directions in Kapila Hingurani and Kapila Hingurani 2 were interim directions based on tentative reasonings restricted to the peculiar facts of that case involving an extraordinary situations of human rights violation resulting in starvation deaths and suicides by reasons of non-payment of salaries to the employees of a large number of public sector undertakings for several years, have no value as precedents. The interim directions were also clearly in exercise of extraordinary powers under Article 142 of the Constitution. It is not possible to read such tentative reasons as final conclusion, as contended by the respondent. If those observations are taken to be final decision, it may lead to every disadvantaged group or every citizen or every unemployed persons facing extreme hardship approaching this court or the High Court, alleging human rights violation or seeking mandamus requiring the state to provide him or them an allowance for meeting food, shelter, clothing, medical treatment, education, if not more. Surely that was not the intention of Kapila Hingurani 1 and 2. So what the interim order was that the government have to pay some financial assistance to the people. That was at the interim stage. Paragraph 16, that 16 and 17 of this judgment, those were the interim orders. So it is very clear, Lordship, that in the interim, a certain situation the Honorable Court wants to preserve. In that situation, interim order is final. Tentative view is it is illegal. But after final hearing, that opinion could have changed also. Otherwise, if it is a final determination, the matter should have been closed at that point of time. So, relying upon this judgment, there is another judgment. (2019) volume 20 SCC, page 326. Paragraph 62 and 63. Here reliance upon the judgment which I have just placed, Lordship. 62, page 350 and 63. This court in the aforesaid decision has observed that it was deciding only interim injunction matter and the findings recorded in the order were prima facie not binding at the time of decision of civil suit and the question to be decided whether HQRL
has lost its private character and has become a public limited by virtue of the resolution dated 2002. In view of the observations made by this court and the order in Ram Purushottam Mittal is not final and is only a prima facie view in the matter of injunction. We find force in the submission of the learned counsels appearing for the appellants that the observations in interim orders cannot be taken as binding even for the purpose of deciding the matter as held in Assam, State of Assam versus Barak Upataka. That paragraph 21 is quoted here. So what basically is can be concluded, and the ratio is that, Lordship, whatever finding is there, whatever conclusion is there at the interim stage, while passing an interim order, cannot have any persuasive value at the time of final hearing. The court has an open field to decide. Court cannot be bounded or have to oblige by the opinion expressed at the interim stage, because at the interim stage, Lordship, all the factors, all the pleadings, all the arguments, all the judgments, all the authorities are not considered at all. If Lordship wants to see that judgment, that interim order, there is no observations, no recordings of the submissions which we have made before this honorable court at the final stage. The whole basis, whole foundation or edifice of that judgment, interim order, is that division bench has declined, the single judge has declined to interfere with the original or to set aside the caste certificate cancellation orders. We have gone beyond that now. And the Honorable Court in Citra's case has said if something new has come out, then there is always a option for the government to review or go for fresh inquiry. That judgment, that law is well settled. Yes, I have argued. But the learned single judge, while passing the interim order on 28th of September 2024, was not then that therefore this judgment of the Supreme Court, whatever is there in the interim order, this is not final. This cannot be used as a precedent. No, it will not amount to a review. Because we want to come for a review, then the other side, as well as we said, that if it requires full-length hearing, then let us hear the full matter. Highly obliged, Lordship.
No, my lord. The Lordship had already heard and reserved for orders, my lord. Only this aspect was. Yeah, factually it is.
And Lordship may pass whenever it is comfortable. Yes, Lordship. Highly obliged.
Deeply obliged.
May it please your lordship. This matter, the petitioner with full lordship.
Sotavare municipal court, na? Sotavare municipal. গভৰ্ণমেণ্টৰ পৰা এতিয়ালৈকে একো আহি পোৱা নাই ফাণ্ডটো ওপৰলৈ
My lord, in this case, the petitioner was initially appointed on compassionate ground, but on master roll basis. Later on, my lord, her service was regularized by the competent authority. But though her service has been regularized, she is still getting the master roll wages instead of the regular salary. This is the limited grievance, my lord.
Made, please tell us. So this matter pertaining to Sarthebari Municipal Board, and the petitioner is still working as master roll worker under the same board, lordship. Now the question is in regard to non-payment of her regular scale of pay. So accordingly, in the affidavit filed by the board, I was being served a copy where it stated that the deponent banks was submitted due to lack of fund, the writ petitioner could not pay her regular scale of pay at para number 5 of the affidavit. However, it been pursued with the government for arranging the funds so that the writ petition can be paid her regular salaries, including areas. Accordingly, lordship, we have written a letter. Accordingly, lordship, we have written a letter on 27/8/25 to the Director of Municipal Administration for whom I appear, lordship. Basically, that affidavit was been filed by the chairperson of municipal board. At paragraph in the affidavit is stated that due to lack of fund, the writ petitioner could not be paid her regular scale of pay. However, it being pursued with the government for arranging the fund so that the writ petitioner can be paid her regular salaries, including arrears. That so and so. So the matter came up before the director to obtain instruction in the same. Lordship, that updated instruction from the government is still awaited, lordship. So sometime may be granted. We'll get that sent from the municipal administration,
Only
lordship.
difficulty, my lord, she is getting the master roll wages. Her kids are studying. She is a widow, my lord. She was appointed on compassionate ground.
No, we are not
At least, my
disputing
lord, the
that.
current salary may be paid at the, my lord, in terms of the regularization order, my lord.
She is getting her earlier salary rupees 6,000. Not the anyways, and the reason is basically lack of fund from the side of the government, from the side of the board. Sorry, not government.
Ms. J. Shetty was there, my lord. She has filed a affidavit. Claims are not disputed. No, claims are not disputed. My lord, but my lord, that is why, my lord, this honorable, she has approached this honorable court, my lord, for my lord. But the, my lord, the government has the administrative control, my lord. Government has the liability also. That is why, my lord, the petition is filed. In one of the case, my lord, this honorable court held that, my lord,
Yes, yes, stay this one. Yes. Mass obligation.
Obligation.
For hearing item 36.
Well, have kindly look at order dated 23/10. I not to CCTV.
So, my lord, regarding CCTV footage, my lord, I have not received from, though I have written to them, my lord. Criminal proceedings, my lord, status, it's not known to me, my lord.
Blood evidence stage plots.
Dismiss. Even though, my lord, there is no bar for doing the departmental proceeding, but
But in fact, if a lordship permit, had it been a case, there is an option in the service rules that if he is convicted, he can be terminated on the basis of conviction. But that option they have not used. They have rather not insisted for any departmental proceeding.
no, my lord, they have done it, my lord.
No.
Pending departmental proceeding, so and so is under suspension.
My lord finds at page 34. 31 is the type of paper. Lord, that has also not been furnished to us.
I have got it, my lord. Enquiry report, my lord.
Expiry report to
29/6/2023. Minor to national welfare. Huh? Statement to put this.
Put the besides the inquiry report to.
Yes,
But if inquiry report was the basis of the order of suspension, then on the basis of the same inquiry report, they could not have terminated me. And if there was no report, on what basis they suspended me? And if they are proceeding with criminal proceeding, Lord, my department proceeding would have ought to have been stayed because of the same facts. They are proceeding in criminal proceedings. The consequences would have followed.
Enquiry report is there, my lord.
Lordship would also consider they have never issued us any because departmental proceeding there has to be a charges that has never been framed. That's why I'm not. Had it been a case where charges were given to us, and if it based on the same facts of criminal case plots, then we also would have a remedy saying that you cannot proceed with departmental proceedings.
Oh, I will go. Yes. Yes, my lord, I have seen the inquiry report, my lord. So when, after my lord filing the FIR, my lord, neither he has forwarded it to the senior officer, nor he has taken any steps regarding the protection of the girl. Instead of that, my lord, he himself forced the girl to put off her pant, even inner pant also. That is the statement. And he absconding, that's why Malad he had to be, according to the Malad provisions, Malad he is dismissed from service because he is a minor girl. I have seen the statements of the victim girl, Malad. Yes, yes, Malad. Everybody's file, we have filed affidavit. Not there. Oh, affidavit is, we have filed, Malad.
Affidavit file করেছে দাদা।
কি লাগে? Affidavit তো file করা আছে।
My lord, in fact, my learned friend has also shown me that inquiry report, my lord. My learned friend during the recess, my lord, has shown me the inquiry report, my lord. But there your lordship would find that he has inquired from the other officers. He has asked me, I have not attended, this is an allegation. So it's not a matter where other would not give an evidence against me, rather they are part of witness in the criminal proceeding. So the whole basis of passing the impugn order is this, that it is not reasonable to hold inquiry. So if others are cooperating, I have not any influence, rather I was arrested, I was in custody for a long period of time. How they could on the very first day come to a conclusion that it is not practicable? The core issue is for your lordship judicial review is this, whether the facts of the case justified that they could reach to a conclusion that it is not practicable or reasonable to hold a departmental inquiry. And what is the intention? The suspension order on 29th reflects, and the question is, Your Honor, the order reflects that pending departmental inquiry I have been suspended. So in one day, they come to a conclusion on 30th that it is not practicable. Now the question is, my lord, whether the impugned order of suspension or impugned order of termination was based on the inquiry report. If the suspension was also based on the inquiry report, then the reasoning follows is, based on the inquiry report, they had taken a decision that he should be suspended pending departmental inquiry. And if the same report forms, yes. Yes, yes. No, no, my lord. I have seen, my lord, I am making a yes, yes, your lordship.
The serious matter, my lord, so he is not cooperating, he is absconding, my lord, how they can inquire? My lord, at a time of inquiry, he was absconding, my lord. How? The police department, my lord, police is police, my lord. And her statement is very important, my lord. It's a minor, my lord. She has candidly, my lord, stated that what happened, actually. That is, my lord, I have not received it, my lord. I think it may not be possible, but because he is the OC of the police station, and it is perhaps it is not possible to keep it, my lord, alive. Because again, CCC camera will show against his, my lord, action. That's why I cannot say, my lord, it is with him. The statement of the petitioners in the, made in the FIR and also a statement under section 164, so the corroborated. She is a minor girl, my lord. The action is prompt. The police has taken a prompt action. If they don't take, it is also flash in the newspaper also. If they don't take any immediate action, my lord, it will send a bad message to the society also. She says, my lord, ছাৰজনে মোৰ গোটেই কাপোৰ খুলিবলৈ দিয়ে, মই খোলা নাছিলো, মোক টাঙোন এটা লৈ খুলিবলৈ দিয়ে, খুলিবলৈ কৈছে, মই ভয়তে খুলি দিওঁ। SI ছাৰে মোক মেডিকেল কি ফটো মাৰিছে, বেয়া ভাষাৰে মোক গালি অশ্লীল গালি অংগীত দিছে। মই ৰাতিপুৱা নিজে তাই SI বাইদেউজনীক সকলো কথা কওঁ, মোক সকলো কথা পায়। Thereafter, my lord, CWC person came and that she was took to the, my lord, shelter in the Jalukbari. The POCSO, as per POCSO, it is 100% my lord, sexual harassment punishable, my lord.
Yes, ma'am. Before the lordship would kindly have a look at Article 311, sub-article 2B of the Constitution.
311. 2B. Reasons to be reported.
The normal rules is there has to be a departmental proceeding, but there is an exception in the proviso to 2. And A, B, C are 3 grounds, your lordship would see. I'm also reading all 3. Where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge. So, my lord, this they had an option. They could have suspended me, and since the charges are based on the criminal offense, my lords, I could have faced a trial. If I am convicted, I can be straight away terminated. C, my lord, where the president or governor of the case may be satisfied in the interest of security. This is not applicable. In our case, applicability is B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practical to hold such inquiry. Now, this is subject to judicial review, my lord. What is the reasoning that has been given based on which it can be said that it was not reasonable practically to hold the inquiry, my lord? Now, for a moment, if your lordship sees the impugn order, yes, my lord, the conduct might be very bad. My lord,
in fact, your lordship would see the inquiry report on which they are relying upon. There are statement by other police. It's not a case where they are not coming. It's only I have not turned up. They called me absconder. Blood, page 34. Where is one minor so and so in all? I am reading the
32.
page 34. Para 2. Peruse the inquiry report dated so and so submitted by the said requirement had to be ordered as allegations were received against so and so, who was the OC, had forced a minor to disrobe her in front of him, and therefore took obscene photos of her. Thereby, the inspector of police had outraged the so and so. Whereas from the inquiry so conducted, and after going through the inquiry report supported by the statement of the victim girl recorded so and so, it appears that the allegation against so and so, which are serious in nature, are substantiated. Milord, he is acting as the judge in the jury, Milord. Whereas the Honorable Guwahati High Court in the case of so and so has observed that both provision of so and so empowers the disciplinary authority to pass such an order as it deems fit, where the disciplinary authority is satisfied for the reasons to be recorded in writing, that it is not reasonable practical to follow the procedure of holding the department disciplinary inquiry, etc. A satisfaction has to be recorded, to be reached as to why it was not practicable to hold the inquiry. Milord, the officer concerned is relying on this judgment. He knows the law. He's knowing it very well what is the requirement. Now he says, where in the present case I am satisfied that it is not reasonably practical to hold the inquiry as prescribed in Rule 9 of the so and so. Instead of cooperating with the investigation, absconding to resist arrest. Well, in one day I am not absconding. What the inquiry officer says that I have not come. So if I have been called, whether I have been issued notice. So this satisfaction, it cannot be reached. But the gravity of the offense will not determine whether they can hold it or not.
Inquiry report is there, but
And in the last part, what I have read, he also assumed that he is a guilty. One person makes an inquiry, he assumes he is guilty. The other person relies upon this report, and I have not been served with a copy. It is prejudicial to the interest of the petitioner. And it is also not a case, Lord, recorded that other witnesses are not coming forward to give evidence.
in the midnight, who will come to give the evidence?
Oh,
In the midnight, he alone, being an officer in charge of the police station, my lord, he forced the minor girl.
There are
And
53
who will
witnesses
come?
in the
Other
criminal case,
officers
my
are
lord.
subordinate officer, they will not come. The constable and the sub inspector will
But
not
if
come.
this has to prevail, my lord, then no inquiry report is required, my lord, in all these cases. The inquiry report is if so sacrosanct, blood, there is no necessity of going for a criminal trial, no necessary for a departmental proceeding. Blood. Yes, blood. That's no, that's for the same very reason. It was more important, blood, that they have to frame charge against me. Very well, Lord. Therefore, Article 311 2A, they could have resorted to, if I am convicted, you just throw me out. But you can't say that you can conduct a department proceeding against me and you are not able to because it's not reasonable. Lord, I am relying upon 2015 8 SCC 86, Lord. I have provided a copy, Lord. Lord, here was the case, Lord, where the delinquent officer was a jailer. And Lord, many terrorists had escaped, Lord. and he was there for a very long period of time. And there, my lord, since the subordinates did not turn up, there the authority took a plea that, my lord, it was not reasonable and practical. No such reasoning is here in our case, my lord. I'd like to draw your lordship's attention the findings from para 18, my lord. Yes. We can start with 17, my lord. 17. May I read, my lord? Before delving into the pointed issues conversed at the hands of the learned counsel representing the appellant petitioners, it is necessary for us to notice the parameters laid down by this court for invoking Clause B of the second proviso to Article 311(2) of the Constitution of India. Insofar as the instant aspect of the matter is concerned, the norms stipulated by this court for the above purpose require the satisfaction of three ingredients. Firstly, that the conduct of the delinquent employee should be such as would justify one of the three punishments, namely dismissal, removal, or reduction in rank. But there is no doubt, my lord, if the conduct is proved, I am liable for this punishment. Secondly, the satisfaction of the competent authority that it is not reasonably practicable to hold an inquiry as contemplated under Article 311(2) of the Constitution of India. Thirdly, the competent authority must record the reasons of the above satisfaction in writing. So there has to be reasons, and that has to be in writing, Lord.
Yes.
Lord, in one day,
Reason is
yes,
written.
reason is absconding. Lord, it's absconding has a nonce, Lord. If you issue notice, you have asked me to come. It is one of the statement. I am also entitled to examine the person who has come to that report, my lord. Yes, and my lord, it is. Lord, if that reason is there, according to me, the reason which they have shown is not a reasonable reason. It's not the. On both issues, I am attacking, my lord. No, my lord, I am attacking on both. Yes. Yes. My lord, reason is there. What they are saying is absconding. Yes, yes, yes. My lord, in these circumstances, yes, my lord. My submission is this, that the recording of reasons is subject to judicial review. Now, your lordship, in the facts of the circumstances, would see if I am absconding, Lord, there could be disciplinary proceeding against me in absentia also. And Lord, that absconding they cannot derive in one day, whether in one day they have suspended me on 29th, they dismissed me on 30th. There was no effort on their part to serve me a copy. Even by that time, their charges were not even ready. It's not a case that they are ready with the charges. Your lordship sees in many of the cases, as suspension is done and charges are framed after 10, 15 or 2 months, 3 months. It's not a case, Lord, that charges were ready. They were supposed to serve me and I am not taking it. I am not there. The inquiry preceded my suspension. And now if your lordship would see, your lordship, my submission would be whether suspension was based on that inquiry or not. If suspension was based on that inquiry, then Lord, the suspension order itself suggests that there has to be a contemplated departmental proceeding. And there is nothing on record on what basis they have suspended me. Obviously on the basis of the inquiry, otherwise before that they don't come to that conclusion. If the same inquiry report, two conclusions are derived, Lord. One, that I need to be suspended pending department inquiry. And on the next very day, they come to a conclusion that no, it's not practicable. Well, which one is to be accepted, my lord? Therefore, my lord, my submission before your lordship's consideration is that whatever the reasoning they have given is, my lord, not justified in the facts of the case. More so, my lord, the inquiry as it reflects, he assumes that I am guilty. Second, my lord, he relies on the statements of other police officers. So how it is impracticable that they will not come up with evidence, whereas they have participated in the inquiry? So how it could be impracticable? My question is this, and the test is whether a reasonable person could come to a conclusion on these facts. that it is not practicable. My lord, allegations are very serious in nature, my lord. I don't dispute that. But the kind of treatment I have been meted out, I don't deserve that, my lord. My lord, that is para 18, 19, 20, my lord, I am relying upon the Tulsiram Patel judgment that is quoted herein. Yes, ma'am. Lord, I may indicate one fact, Lord, he has already superannuated from service.
Obliged.
Deeply obliged.
Item 35.
Record be with lordship, my lord.
May it please the Lord. My lord, the background of the case, I'll give a factual, my lord, narration. There was some appointment. Yes, 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 yes. Approved. Yes, no, the secretary approved it. If only just factually two aspects, then I brought one decision, my lord. Basically, lordship wanted to know whether any authority on this point. I brought the judgment, my lord. Before that, if your lordship would kindly come to page number 28 of the writ petition. This is, yes. Can be construed as a misconduct. My lord, this was the letter from the Chief Minister's Secretariat. Kindly see the last para. After saying that a joint secretary level officer should, conduct the inquiry, it is requested that the allegations may be inquired into by an officer of the department not below the rank of joint secretary, and report may be submitted to this office with views of senior most secretary within 3 weeks. So whatever inquiry report is submitted by the inquiry officer, that will be submitted after it is vetted by the secretary of the department. Now, my lord, one just aspect, if your lordship would kindly take their affidavit, my lord, page number 154. While submitting the inquiry report, this was the forwarding letter. This was by Secretary of Handloom and Textile to the CM Secretary. I'm reading the sub-para, my lord. It may be mentioned here that the allegation submitted by anonymous, hence it was not possible to collect more information or witness in this regard. As per available record, the inquiry report submitted by Sri Hariprasad Bora, Joint Secretary to the Government of Assam Handloom and Textile and Sericulture Department, appears to be in order. My lord, if I am guilty, then this secretary is also guilty, going by the Supreme Court decision in G.S. Sharma's case. Because if a basket of apples stings, then all the apple will sting. It's not that you will just pick up one apple and say it stings. Now, my lord, I'll relying on the one judgment of the Supreme Court, 1979, 2 SCC 286. I said it. Copy to this. My lord, Union of India versus J. Hamed. 1979, 2 SCC 286. Para 11, my lord. So after reading this, I'll hand over the copy, my lord. A Union of India versus J. Ahmed. But what had happened, my lord? This gentleman, J. Ahmed, he was, my lord, Deputy Commissioner of the Undivided Dorong District. During the language disturbance, my lord, there was some unrest. Now he could not perform his duty properly in as much as, my lord, he was not successful in handling the situation. A disciplinary proceeding was initiated against him. Eventually, my lord, matter traveled to Supreme Court. Now, it was in that context the Supreme Court at paragraph 11 has observed মই কালি কৈছিলো নহয় দুটা কপি আনিবৰ কাৰণে। Para 11. The code of conduct set out in the conduct rule clearly indicates the conduct expected of a member of service. Yes, yes. এইগুলো একটা জুনিয়র জাজের জাজমেন্ট লিখিলে হাইকোর্টে স্যাটিসফাইড করে ইনকোয়ারি রিপোর্ট হ্যাঁ না সেই বস্তুটো বেলেগ Yes, has also got it, Miller. Yes. The code of conduct as set out in the conduct rule clearly indicates the conduct expected of a member of service. It would follow that conduct which is blameworthy for the government servant in the context of conduct rules would be misconduct. If a servant conduct himself in a way inconsistent with due and faithful discharge of his duties, it is misconduct. A disregard of an essential condition of contract of service may constitute misconduct. This view was adopted in so and so, so and so. Misconduct means misconduct arising from ill motive, acts of negligence, error of judgment or innocent mistake do not constitute such misconduct. Kindly mark this, fellow. Error of judgment or innocent mistake do not constitute misconduct. In industrial jurisprudence, amongst others, habitual or gross negligence constitute misconduct, but in Utkal machinery, in the absence of standing orders governing the employee's undertaking, the unsatisfactory work was treated as a misconduct in the context of discharge being assailed as punitive. In as Govinda Menon versus Union of India, the manner in which a member of the service discharged his quasi-judicial function, disclosing abuse of power, was treated as constituting misconduct for initiating disciplinary proceeding. A single act of omission or error of judgment would ordinarily not constitute misconduct, though if such error or omission results in serious or atrocious consequences, same may amount to misconduct, as was held by this court in so and so, where it was found that two mistakes committed by employee while checking the load sheet and balance chart would involve possible accident to the aircraft and possible loss of human life, and therefore the negligence in the work in the context of serious consequence was treated as misconduct. Now this is important. It is, however, difficult to believe that lack of efficiency or attainment of higher standard in discharge of duty attached to public office would ipso facto constitute misconduct. I am on this, my lord. I am reading this line again. It is, however, difficult to believe that lack of efficiency or attainment of higher standard in discharge of duty attached to public office would ipso facto constitute misconduct. There may be negligence in performance of duty, and the lapse in performance of duty or error of judgment in evaluating the developing situation may be negligence in discharge of duty, but would not constitute misconduct unless consequences directly attributable to negligence should be such as to be an irreparable or a resultant damage would be so high that degree of culpability would be very high. Now, in this case, my lord, it was a complaint, was an anonymous complaint. Under the, my lord, CVC guideline, an anonymous complaint is not even required to be inquired into. That's the settled position of law. Now, we have a CM secretariat, my lord. We have a daily seeing, my lord, how they are trying to eradicate corruption, everything. So therefore, my lord, people of Assam is seeing every day, in and out, what is happening in the state. Now, my lord, I was interested with an inquiry. I conducted an inquiry Whatever I found, I gave. I may be wrong, I may be right. Supposing I am wrong, can it constitute misconduct? That is the question. In my humble understanding, my lord, going by the ratio laid down in this judgment, such acts cannot constitute misconduct. Therefore, my lord, initially there was a punishment of withholding of one increment. When I filed an appeal before the appellate authority, it was converted into a punishment of minor punishment of censure. Now, as a result of the censure, my lord, all my juniors of 1993 ACS batch, they have become secretary. I'm still languishing as additional secretary. And my lord, my learned friend makes a submission that he has not been superseded, that his turn, whenever his turn will come, his case will be considered. My turn is already over. So therefore, my lord, it's a clear case where, my lord, the authority exercised a power which was unwarranted, my lord. End of the day, my lord, what is Article 14? Article 14 gives me protection from this only. If there are exercise of power which is otherwise not consistent with the rule of equality, then it has to be construed as an arbitrary exercise of power. Then my secretary who vetted, endorsed my report, why no action has been taken against him? In GC Sharma's case, my lord, Lordship knows that is a case which emanated from our High Court. Bongaigaon Refinery's case, my lord, a particular site selection in 9 Mile. My lord, there was a committee. Now, out of the committee, my lord, GC Sharma was picked up for, in fact, I defended the decision as a counsel appearing for Bongaigaon Refinery. We succeeded before the single judge. Division bench, my lord, interfered. We went to Supreme Court. Supreme Court maintained the division bench judgment, where Supreme Court clearly said, if it was the action of the committee to select a particular site, if the selection of site was bad, then you have to find everybody guilty. You cannot just pick up one. So that is my second limb of argument, my lord. If I have committed a wrong, then the secretary of the department has also committed a wrong, because he has endorsed my report. GC Sharma, huh? I'll give that, my lord. I'll give that citation. GC Sharma. And GC Sharma, and there is one more judgment of Honorable Supreme Court from Andhra Pradesh, my lord. There also what had happened, one, my lord, assistant executive engineer was sought to be penalized, while no action was taken against the executive engineer who had vetted it. There also Supreme Court said, I'll give both the judgment if it is not inconvenient tomorrow at 10:30, my lord. No, my lord, the consequence of I not getting nominated to IS is this proceeding. So if a lordship interferes with the proceeding, naturally, my lord, they are bound to give me, they're bound to hold the review DPC, and my lord, they will have to take care of my promotional career progression aspect. That is my submission, my lord. Lordship, I'm sorry, my lord. Tomorrow at 10:30, my lord, I'll give both the judgments, my lord. Yeah, I'll give the citations.
My lord, I have made my submissions, my lord. My respectful submission before your lordship is, my lord, annexure B and C are the, after receipt of the report, annexure B and C, page number 155 and 156. These are the observations, my lord, found as regard the inquiry report submitted by the petitioner, my lord. He made a perfunctory inquiry, and these are the observations, my lord. Lordship may kindly take note of that. But he.
Exactly.
My lord, in fact, the inquiry report is very much clear. Inquiry report is very much clear that he has not even. My lord, the petitioner, he has to discharge the duty, and kindly see, my lord, the annexure.
The secretary also has to discharge the duty.
Page 28, annexure 1 has been relied.
Girish
Lord.
Chandra-
Girish Chandra Sharma versus, no, my lord, BRPL versus Girish Chandra Sharma. Yes, that is the judgment.
But the situation in selecting a particular site for some construction cannot be equated with this case, because here the petitioner, being a joint secretary, was entrusted as an enquiry officer to conduct an enquiry. Here he is the sole person to do the enquiry, my lord. Not a group of persons who were entrusted to do the enquiry. Kindly see the page number 28 here. What has been said, my lord? Page 28, Annexure 1. This has been read, my lord. I am just at the cost of repetition. Kindly see, my lord, page 28. After noting down everything, it is requested that the allegations may be inquired into by an officer of the department not below the rank of joint secretary, and report may be submitted to the office with views of the senior most secretary. With the views but the enquiry has to be conducted by the officer concerned who has been entrusted, the joint secretary level officer. He will do the enquiry. It is not a order that the two persons will do the enquiry, my lord. It is the petitioner who will do the enquiry. But here kindly see the prayer of the petitioner is for setting aside the departmental enquiry, and the enquiry report, my lord, I have already read. Kindly lordship take note of that. Findings are recorded at page 104 to 106, my lord. Lordship, kindly take note. I'm not reading, my lord. The punishment of censure, that is under challenge, my lord. Lordship, I am placing reliance on three decisions, my lord. Lordship, the 1995 6 SCC 749, my lord. The BC Chaturvedi matter, my lord. (1995) 6 SCC 749 BC Chaturvedi versus Union of India, my lord. But here the authority, after conducting a detailed, the inquiry, ultimately has imposed a punishment, and in appeal it was reduced to censure, and that censure is under challenge before your lordship. Para 12, my lord, kindly come to para 12 and 13. I am relying, my lord. Yes. Para 12 says, my lord, has lordship got, my lord? Lordship, judicial review is not an appeal from a decision but a review of the matter in which the decision is made. Power of judicial review is meant to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eye of the court. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is concerned to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with, whether the findings or conclusions are based on some evidence. The authority entrusted with the power to hold the inquiry has jurisdiction, power and authority to reach a finding of facts or conclusion. But that finding must be based on some evidence. Neither the Technical Rule of Evidence Act nor proof of fact or evidence as defined therein. The authority accepts the evidence and conclusion receives support therefrom. The disciplinary authority is entitled to hold that a delinquent officer is guilty of the charges. The court tribunal, in its power of judicial review, does not act as an appellate authority to reappreciate the evidence and to arrive at its own independent findings on evidence. The court tribunal may interfere where the authority held the proceeding against the delinquent officer in a manner inconsistent with the rules of natural justice and in violation of statutory rules prescribing the mode of inquiry, or where the conclusion or finding reached by the disciplinary authorities based on no evidence. If the conclusion or findings be such as no reasonable person would have ever reached, the court tribunal may interfere with the conclusion or the finding and mold the relief as to make it appropriate to the facts of each case. My respectful submission is that the punishment imposed is on the basis of the inquiry conducted and on the evidences. Para 13 also, I am relying. But the next case, Lordship, Lordship, next Malad, I am relying on 2015 2SCC 610 Malad. This is Union of India versus P. Gunashekaran. 15 2SCC 610. Lordship, may kindly note para 13 Malad. The apex court has held Malad in para 13 Malad. Court has recorded that under Article 226, 227 of the Constitution of India, the High Court shall not reappreciate the evidence, interfere with the conclusion in the inquiry in case the same has been conducted in accordance with law, go into the adequacy of the evidence, go into the reliability of the evidence, interfere if there be some legal evidence on which findings can be based, correct the error of fact, however grave it may appear to be, go into the probability of punishment unless it shocks its conscience. My respectful submission is, my lord, the manner in which the petitioner has conducted the inquiry, ultimately the authority has, the departmental inquiry has conducted and the inquiry report proves, and punishment was imposed, it doesn't shocks the conscience of the court calling for interference in this case, my lord. The third decision, my lord, is 1989 2SCC 177, my lord. Yes, my lord. No, these are my lord, ultimately my respectful submission is that 1980, yes. BC, my lord, kindly, my lord, para 1989, para 27, that's just, I would like to read, my lord. 2 SCC 177. Union of India versus Paramananda, para 27. Lordship.
Union of India, Paramananda, hit a point.
Para 27, we must unequivocally state that the jurisdiction of the tribunal to interfere with the disciplinary matter or punishment cannot be equated with an appellate jurisdiction. The tribunal cannot interfere with the findings of the inquiry officer or competent authority where they are not arbitrary or utterly perverse. It is appropriate to remember that the power to impose penalty on a delinquent officer is conferred on the competent authority either by an act of legislature or rules made under the proviso to Article 309 of the Constitution. If there has been an inquiry consistent with the rules and in accordance with the principles of natural justice, what punishment would meet the ends of justice is a matter exclusively within the jurisdiction of the competent authority. So, my lord, my respectful submission is, my lord, the censure, there is no ground, my lord, to interfere with the punishment of censure here. So this is my respectful submission, my lord.
Like just this judgment, my lord, my learned friend has placed 3 judgments. In none of the judgments, the issue was whether a public servant was charged with a misconduct. They were charged with misconduct. So in a case where one is charged with misconduct, and thereafter the scope of judicial review is very circumscribed, we all know. But here in this case, we are involved whether it's a case of misconduct to even call for a disciplinary proceeding. Therefore, how these judgments can help anybody? Well, everybody knows what is the jurisdiction of how, to what extent power of judicial review can go. Yes, if there is some evidence, that's the end of the matter. It's not a lordship jurisdiction is not like that of an appellate court. It's a power of judicial review against the decision-making process. But here we are concerned, therefore it is said, my lord, a decision is an authority for what it actually decides. A sentence in a judgment should never be read as a statute. That's what Supreme Court has said time and again. It has to be read in the context in which the judgment is rendered. In those, B.C. Chaturvedi is a well-known judgment, my lord, where it was no difficulty in appreciating that the person concerned was charged with misconduct. Thereafter, there was an inquiry, thereafter punishment imposed. That is not the case here. Here the case is whether the charge level against me itself amounts to misconduct. If it is a misconduct, that would be a different aspect. If it is not misconduct, then there is no requirement of going to all these aspects. Therefore, in my humble submission, my lord, these judgments are not applicable to the facts of the present case. That's my humble submission. Deeply.
I would have, my lord, agreed with that. Had at the time of issuance of the show cause, my lord, the petitioner would have come. He has come after censure. When the departmental proceeding is finished and the penalty was, my lord, ultimately reduced by the appellate authority, now the censure has been challenged. If the show cause at all is not maintainable, then, my lord, it's a different case. Lordship. Lordship. My lord.
Deeply.
Alright.
Okay.